Good morning, students.
Good morning, sir.
Good morning, sir.
I believe we can commence discussion. We have enough members, enough students in the class now. So we can commence our discussion. Yeah, construction contract dispute resolution. Previously we have discussed the concept of dispute, conflict, dispute resolution in its form, the genesis of conflict, its generic nature, and of course, we have looked at how to manage conflict in resolving disputes, the different kind of models that we could look at, and of course, the mode of conflict and the way to see how you can manage and resolve conflict or disputes when they arise on construction projects. And we had looked at the international dimension, the need for professionals to understand the importance of the United Nations, the UN, in terms of the conventions and treaties, and that's being promulgated by the World Organization. And of course, we had said that international contract requires a deliberate private approach such that the way you manage it, the individual, participating countries' constitution may be conflicting. So they need to look at it in terms of the private arrangement that the parties are having. And of course, being guided by the international conventions, treaties, and standards. So that is why whenever there is whenever you are involved in international construction contract, there is need for you to understand some of these conventions, treaties, and of course standards. Vis-a-vis the whatever form of contract that is being used. We had mentioned previously too that the FIDIC form of contract is more like the most popular among those form of contract that are being used for international construction contracts. Now we are to look at dispute resolution, and of course, let us discuss them in detail, in further details. Remember, we have said that the major two prongs of dispute resolution were actually adjudicative and consensual. Adjudicative that involves the litigation and arbitration forms, and of course the consensual that has to do with minimal formal relation. That is more like a faster way to resolve disputes. It is usually informal, and the process is somehow mutual, among the parties involved in the contract. So when we talk of litigation, it should be understood as bringing an action to court. When a particular party is trying to enforce rights, and of course, you engage the process by contesting your legal, rights, and that action usually would be taken care of in a court of law. So whenever you talk of litigation, usually it is imposing. It will be binding on the parties because it will follow the civil procedure. It is about the constitution, usually in a particular country. So once you mention litigation, then whatever decision that is made by the party will be binding on the party, because the party will know that those that are determining the case, they have the right, they have the capacity to actually, execute whatever they pronounce, which will be binding on parties to that contract. So, and it involves a series of steps, which will lead to a court trial, and of course, ultimately, resolution of the matter in the court of law. So that once the judge made his pronouncement of his decision, the decision of the court will become binding on the parties to the contract. Litigation is not uncommon in the construction industry. It is actually something that we do see because of the adversarial nature of parties, a tendency for the parties to prove that, yes, all to me, none to you. What we mentioned previously, concept of the zero mindset, that yes, I'm right. So those are the things. Any dispute that the parties are unable to resolve on time, and of course there is this concept of the zero mind, that yes, then, and the two parties are trying to be assertive in their position, they are competing. Of course, once such a case is unable, the parties are unable to resolve their cases, that means they may push the case to litigation. And of course, in litigation, whatever the judge decides becomes binding on the party. However, because of the adversarial nature and the complexity that we have seen in the construction industry, when you have a contract, there is always a provision for dispute resolution that will be agreed by the parties to the contract. So there are agreed terms in the clauses in the construction contract form that will make the party to agree that in case there is a need to resolve any particular dispute, they may resolve it through a particular dispute resolution procedure. And that is what actually got the idea that, of course, parties cannot be competing all the time. And any small matter, you say you want to go to court, litigation. No, there should be a better way of resolving the dispute without necessarily taking yourself to the court, without necessarily competing or being too assertive. You need to accommodate something. So yeah, that actually brought us to the concept of the alternative dispute resolution mechanisms. So these are procedures that are offered by different arbitral institutions. Well, today, we have arbitral institutions that actually follow and manage dispute, resolution matters. Hello, students, are you following?
Yes, sir.
Yes, sir.
Yes, sir.
Yes, sir.
Yes, sir.
So those dispute resolution mechanisms, those ones that are available to the construction industry will include mediation, adjudication, arbitration, expert determination, and of course, court proceedings. The court proceedings is the dispute resolution mechanism. And of course, we had said that it is adversarial. It is competing. It is when people are being assertive, they don't want to allow it. The concept of the zero mind will lead to that anyway. So, and of course, the alternative dispute resolution is generally classified into at least 4 types. You have negotiation, whereby it is just between the two parties. They find a way of resolving the dispute among themselves. You negotiate. You have mediation. You have collaborative law. And of course, the father of them all, which is almost, initially was supposed to be something of ease, but it's becoming more, it's becoming more formal too, and that is arbitration. So sometimes conciliation is included as a fifth category, but for simplicity, may be regarded as a form of mediation. So mediation, conciliation, I've mentioned it before, because we have so many methods when it comes to alternative dispute resolution method. And we have looked at conciliation, mediation, and, professionals have been able to say, particularly the reaction of the Chartered Surveyors, RICS, that conciliation, mediation, we can put them, together as one. So conciliation is a form of mediation. So if you look at alternative dispute resolution, its tradition varies somewhat from country to country. The way this will be resolved here in Nigeria may be different from the way it will be resolved in the UK, for example, because of the different culture, different norms among the people. So it may differ. There are significant common elements that could justify it as ADR, notwithstanding the differences in the regions, as it were. The processes of dispute resolution is important when we resolve conflicts. And of course, it is necessary for us to understand that any process that leads to a resolution, whether you give it a name or you didn't give it a name, is a dispute resolution process. Once you observe that there is misunderstanding, disagreements between any two parties or more, and you are able to resolve the problem, it is a dispute resolution process. The RICS assessed the spectrum of dispute resolution from many different, labels. Like I said earlier, you can have so many names for dispute resolution, different, especially across regions. But so far, the process has to do with you not going to litigation. There is no court involvement, and able to resolve the matter, the disagreement, and the parties involved were able to go in peace and agree among themselves. Then it is also a dispute resolution process. So according to the RICS, they looked at this and reduced the concept of dispute resolution distinctly into 3 processes, believing that all dispute resolution techniques are built upon these 3 processes. And of course, they have called that the 3 pillars of dispute resolution, according to the Royal Institution of Chartered Surveyors. The first of it is negotiation. Negotiation is problem-solving efforts of the parties involved in any construction contract. And it is voluntary. There is no third party per se. Third party. They are just willing that, this impasse between themselves, this problem, this disagreement, they need to solve it. And they meet among themselves, they reconcile, and they agree. They negotiate. Oh, no, I cannot give this. Oh, you have to give this. Okay, what do we do? Okay, I can understand. Okay, but it's a claim. Okay, I know it is right, but you did not inform me. All this. Okay, no problem. Okay, instead of giving you 10, I'm going to give you 7. Okay, no problem. But the 7, you have some. That's negotiation. Back and forth. You cannot give this, you can give that, and both parties eventually agree on something. They negotiate among themselves. So it is not impossible at times that a third party could be called upon or be involved. Someone that is having skill to coach, but he's not involved per se in looking at bringing the two parties together. He will just maybe he will go to party A. You can understand that with him. You can give him that understanding. Go to party B. It is understandable, you know. Just like I will refer again, husband and wife, when there is dispute, maybe they have to go to their chaplain, religious leader or somebody, you know, and because they will not be seeing the two of them. They want them to talk by themselves, but they would have informed the husband. And you need to understand your wife. You know, there are some excesses from their end, but you know, it is God that always take control. You just need to be prayerful. You go to the wife too. You know your husband. Men are always, they are domineering. It is God that put them in that position. Just try to understand with him. You see, somebody is doing that behind the back too, but they could know it doesn't really matter. But it is the two parties that will now look at themselves and say, my wife, what you did to me, I don't like it. Oh, my husband, you are just too domineering. You need to give me understanding now. After all, I'm your wife. You know, they just negotiate among themselves. Oh, you are being domineering. Well, I understand it is men that used to do that. Oh, your excess is too much. Well, women, they are like that. It doesn't matter. Even they couldn't get themselves satisfied by what God has given to them. So they have to add to everything they know they possess. God gave them ear, they add to it. If God give them they have another nail that they put to it. Sorry. So, you know, that kind of understanding, they could, okay, you negotiate. I understand your excesses. I understand your domineering nature. And they agree and they move on. That's negotiation. That's part of it. So the second process is mediation or conciliation. As earlier said, mediation, conciliation, in which there is a third party in that. The major issue there is that there is a third party. And it is that third party that will now mediate. They are aware that it is this third party that wants to resolve the dispute, you know, among them. The function of the third party is to facilitate resolution process. He is just to facilitate the parties to understand themselves and agree. It is just like an intervention, but that kind of intervention will not lead necessarily to a binding, you know, resolution. Whatever they are to agree, it's going to be relatively mutual. That okay, is that what you want me to do for him? Is that what you want me to do for okay? You know, the part that is, you know, influencing the decision.
Please, I was binding resolution.
What? Come again.
What's binding resolution?
Binding resolution means that once a decision has been made, that okay, party B, what you did is wrong, so you have to do this. So that statement of saying you have to do this is binding. You have no choice, you must do it. Like I said, in litigation, which is court case, if the judge says, this is my judgment on this accused, okay, it means whatever the judge pronounced as his judgment is binding on the person. It is binding
Okay,
decision
sir.
that takes people to jail. So, for example, the contractor and the client, they are having a disagreement on a particular payment. The contractor is arguing that it's a variation. It was not part of my initial contract. And the client is saying that that variation is not before me because I didn't have budget for that. And eventually, they now have a party that have to, you know, mediate between them. That's it. No, client, this was not part of the initial contract. So, having done it, you have to pay for it. If it is mediation,
Okay,
conciliation, the man may pay, may not pay. But if it is in a court of law, the judgment, that pronouncement, that decision will be binding on the part that the client, you have to pay, then he must pay. The same thing in arbitration. Arbitration decisions too are also binding. Then we now have the third process, which is adjudicative process. And of course, in the adjudicative process, according to the NIQS, that is the one where you have the arbitration and litigation. As mentioned, the final outcome of the third party is imposing and it is binding. So decision in arbitration and of course in litigation is binding on the parties. So whatever the pronouncement is or decision is, it will be binding. So we have this diagram, and this diagram is telling us about the dispute resolution landscape, the way we should see it. So this concept, you see, we have looked at different ways, different discussions on dispute resolution. But our institution for quantities of yours, the RIs are look at it in this way. And the landscape for it. You would have passed through this either of these three processes in resolving dispute. The first major one is negotiation. The second major one is mediation. And of course, the third one is adjudication. Those are the processes. Fact find, expert appraisal, early neutral evaluation. Don't forget, I mentioned something that under negotiation, the major issue is the interest of the parties in contract. Necessarily, there is no third party. So they just believe that, okay, but before I agree, I need to find out the truth, the facts on this matter. I need to appraise the situation. Am I right? Is it wrong? Was it right? Am I wrong? An early neutral evaluation. If I should drag this matter beyond necessary time, it may eventually affect my gains on this project. So because of that, it's better I resolve this and we move on. Let me just negotiate it and we move on. That's negotiation for you. Mediation, of course, you have a third party who is trying to reconcile your difference and ensure that there is peace, there is mutual understanding. And of course, the third one is not about you per se. It's about your argument. Work from the beginning that you work. You actually know about what is transpiring or what kind of transaction is going on the project. Okay? An ombudsman, of course, that is more like having somebody that, okay, this right should be known by you. This right should be known by the party too. And of course, such opinion by such individual should be respected. Adjudication, closer to arbitration too, but less formal than arbitration. Expert determination, those that knows will be the one to tell you that this is right, this is wrong. They are experts. So once they determine the case, you know that, of course, that is the way you should see it. More like a judge. You know, the judge is an expert in deciding a case. So, of course, a quantity surveyor is an expert in deciding case on cost of construction projects. Architects, argument on design. If there is any argument and you say, no, what did the contractor design for himself here? The design and build is wrong. Now, architect, can you judge on this? So, expert determination is on knowledge, and of course, decision of the expert could be binding. The same thing arbitration. It has a procedure and it is recognized by the law of the land. So once you have an arbitration clause in your contract, the decision of the arbitrator is binding. And of course, the litigation. So the idea on the third landscape that we have here is to let you know that that one transcends your interest. It transcends your opinion. Whatever decision that occurs or established on that will become binding. And of course, parties have no reason not to respect it. You must respect the decision